Hello again, my name is Mark Silver. I'm doing a series of programs on forensics for immigration, criminal, and civil litigation lawyers. I'll tell you about myself. I've been working at this for just over 20 years. I've done thousands of cases for immigration and criminal lawyers. I've also done many cases for civil litigation lawyers, including consultation. I'm a psychiatric social worker with a doctorate in psychology. I'm a lawyer in New York. I have a background in political science and family systems therapy. And my main goal in all of these programs is to emphasize the absolute importance of humanizing the client, of recapturing the client's psychosocial background, thoughts, feelings, behaviors, community, family ties, issues related to the client's judgment and thinking and so on, so we have a better sense of who this client is as a human being. Today's immigration forensic presentation will be on hardship criteria found in waiver and cancellation removal cases. And the exact title is Extreme Hardship Criteria in Waiver and Cancellation Removal Cases. However, hardship does come up in other kinds of cases, but I do want to focus specifically on these legal issues. And the subtitle is Clinical Strategies and Challenges for Immigration Lawyers. And I say that because, and I've said this in many other CLEs I've done, I've really tried to stress the importance of this to AILA National, and they have not come on board in having an opportunity to present clinical forensic evaluations in CLE format for immigration defense lawyers, so they'll know how these evaluations are undertaken. As I said in other programs, in contrast, local AILA chapters have really been quite interested and very receptive, and I've done many of them. I do them for free, and I'm more than happy to do them in the future. The issue today is hardship criteria. My specialty is criminal mitigation for immigration defense lawyers, and I've said this before. Please email me if I'm mistaken. I think I'm the only criminal mitigation expert in the United States who has a subspecialty for immigration defense lawyers. Criminal mitigation is, of course, for immigration for criminal defendants who will be sentenced or who must provide a plea to the district attorney. And criminal mitigation allows an opportunity to present anything and everything in the criminal defendant's background so that the prosecutor, but also the judge in criminal court, will gain a better understanding of who the person is, and hopefully there'll be a greater opportunity for justice and a better understanding of the defendant's thinking and judgment and so on. That's extremely important in waiver and cancellation removal cases where you have fraud or misrepresentation, or the respondent has committed a crime or multiple crimes. But obviously another very core issue in waiver and cancellation removal cases is hardship criteria to qualifying family members, and that's what we're going to focus on today. The hardship criteria that I want to talk about today may not be hardship criteria that you necessarily find in AILA printouts or at an AILA conference. These are clinical criteria that forensic experts use, such as myself, when evaluating a case. The main book on the subject is Handbook of Mitigation, Criminal and Immigration Forensics. My book came out in a 7th edition a few years ago. It has specific chapters on every single program I provide. It is, I guarantee you, the cheapest book you'll ever find for practicing lawyers, and there is a specific chapter on hardship criteria. I've even updated hardship criteria since then, and I want to share those updates with you in this program. The other book is called Psychosocial Evaluations and Consultation. All of these can be found on my website. I really wrote this book for civil litigation lawyers, but the truth is that it's crucial for lawyers to understand how to elicit material from their clients. It's something we don't learn in law school. There's no courses on how to interview clients. there's only a few courses on advocacy in the courtroom. And it's very important because so many of these clients have experienced trauma in their countries of origin, family that have committed all sorts of abuses towards them. There maybe have been pervasive poverty, the ubiquity of corruption, drugs, alcohol, all sorts of indignities that the person suffered. And it's important to be able to work with these clients and to speak with them and understand the hardship issues. I always try to integrate theory with practice. Please don't hesitate to email me. I'll send you back a sample redacted report. Just put in the subject line waiver sample, and obviously it'll have names and pertinent information about the clients changed. But as I said, I do try to integrate theory with practice, and that's probably the best way to do it. I want to get right into the hardship criteria. I usually give more background information when I do a formal CLE. Thousands of lawyers, tens of thousands of lawyers have listened to these CLEs in the US and even some places in Canada. But for this program now on YouTube, I just want to focus on the extreme hardship criteria itself from a clinical perspective. So the first one is parental history of hardships. The parent is not a qualifying family member. So why do I include it in the evaluation, and why would I include it in the report or when I testify in immigration court? First and foremost, it's because the hardship criteria pertains to the qualifying family member, but also anything that serves as an extension of that qualifying family member. And I'll give you several examples as I go through this program, and I'll give you an example right here for parental hardships. I saw this case. This was a long time ago. It was a family from India, and there is a familial history of asthma, which is a respiratory issue. And the dad, who was the respondent, came to court with his two kids, and the kids were doing well. They had medication for asthma, which they were able to benefit for through a nebulizer. It's medicine you put in a machine, and it comes out as a vapor, and you can inhale it at night, really all night. It's just fantastic. You just plug it in. So I got to court, and the client did not look well. I was asking what's wrong, and this is one of the reasons why it's so great to go to court for clients and not do it through through audio-visual. And we spoke, and it turned out that the client's mom had just passed away. I said, I'm very sorry. I understood that the mom was not that elderly and was rather healthy, and I was sort of inquiring. And it turned out, he said, well, my mom died because there wasn't enough electricity in India. And I didn't understand quite what he meant, but it became clear that his mom, like him and his children, suffered from asthma, and his mom also had a nebulizer with, the medicine put into the machine, which she would benefit from at night. But there were these rolling power outages where he lived in India, and because there were power outages, the nebulizer could not work because it was plugged in. In other words, a seemingly simple issue, this parental hardship for him and his mother was very serious, but it reflects as an extension what the children would suffer if they would return to where their dad grew up in India, where they also would not benefit from regular asthma medication because of electricity, because of the lack of electricity would prohibit them from gaining this medication at night. So that's one kind of example. Another kind of example, I see a lot of single parents, and some of these single parents are doing their very best in the United States, caring for their children. But if they're deported, to go back to a place where being single parent is stigmatized, and there may be a sense that that person should be blamed, even though very often the single parent has been the victim of physical, emotional, other kinds of abuses by the children's other parent. This is another example where getting a history of the parents, even though the parent is not the qualifying family member, will serve to gain insight into the quality of life that the child will experience in the parent's country of origin as an extension of their own issues. The second major area of hardships that I think of clinically is local parentis. This is something that I'm telling you, you'll never see this in an ALA seminar. That's why it's so important to have these. I see this all the time, and I write about it all the time. And I'll give you an example. I see a lot of parents who have come to the United States, and they're doing their very, very best. They love their children. They're working hard, sometimes 2 jobs. On the weekend, they do their best to take their kids out. They go to church. They go to baseball practice, whatever they're doing as first-generation immigrants struggling to survive. You know, it's a foreign culture, foreign language. They don't have a support system and so on. Clearly, the most important issue for children is to go to school every day. But the children don't have parents who are educated. Many of these parents have perhaps a equivalent of a grade 6 education in their country of origin. They had to leave school because of poverty, or they had to help support their parents or younger siblings, and for other reasons as well. In fact, I see many clients from Central and South America whose Spanish is actually quite poor because they did not have a middle school or certainly not a high school education. Local parentis issue is that the parents, they love their children very much, but they cannot understand the children's educational needs. They cannot advocate for the children. They cannot do homework with the children. Sometimes they can't read with the children. These children would be on their own if it was not for the school system. The school system evaluates the children. The school system makes sure that kids are getting from point A to point B to point C to D. They're getting these report cards every year that reflect their progress or delays or educational or academic challenges or even deficits in learning. Local parentis reflects that the school system itself stands in for the parents, not in a patronizing way, not in a negative way, but in a positive way. And if these children are forced to relocate to their parents' country of origin, where their parents did not have an education, there won't be an infrastructure for these children to advocate for their needs, particularly if they have specialized developmental and or learning deficits or learning disorders of one kind or another. This is a very important issue, and it points to the fact that the children must remain here in the United States with their parents for the school system. It's very similar to healthcare issues. We never expect parents to advocate or understand children's healthcare issues because they're not physicians. You take a child to a pediatrician, you take a child to a specialist if it's recommended, and so on. This is a crucial issue that I always talk about in my CLEs and in my book as well. The third major hardship clinical criteria is particularity of relationships. This is very important to understand, and again, I haven't seen this in the ALA literature, and I'll give you 1 or 2 examples. I saw a client many years ago, and it was just a disaster of a case. He was about 22 years old. I believe he was from Trinidad. His parents and siblings were here without documentation. The only qualifying family member that the client had was a daughter who was about 6 or 7 years old, and for various reasons, she could not be interviewed. My client's daughter's mom was living in New York as well. She hated her former boyfriend, and apparently she went to a master calendar. I don't know why she was there. She went to a master calendar hearing, and she said something like, "Deport his sorry ass out of the United States." Not a great case to start with. Make it worse, the respondent was in the Pokey in upstate New York jail, and I went to visit him, and he was just a very loving guy. He was, he got himself some trouble, but he really loved his daughter. He was actually quite a decent human being, and his family was quite decent, and it was just very sad and difficult. And I thought, well, what the hell am I going to do here? What are the hardships? He wasn't providing that much financial support. His daughter lived with the mother. His daughter did not live with him. He had no other qualifying family members, no other children. And I thought, what am I going to do? And I went back to the standard. The standard is extreme hardship for that particular individual. And what I said was, in court, I said, look, this guy is not the father of the year. But that's not the legal standard. You're asking me to evaluate the case. my evaluation conclusion is this. For this little girl, the added benefit of having her father in the United States is huge. It will allow her mother to continue to go to nursing school and graduate and have a better life. It will allow her to have, quite frankly, a babysitter when her mother's not available. It'll allow her to have a second parent. Does the father, my client, give a lot of financial support? No. But you know, an extra $100 or $200 or $300 a week for this child will make a great deal of difference. So the particularity of the relationship, he may not be the father of the year, but the question is, for this little girl, what will be the added benefit? It will be enormous. Another example of particularity of relationship is couples that don't have children. When I was growing up, you'd ask young couples, which was completely rude, you'd say, when are you going to start a family? The implication being that if you were a married couple and you did not have children, you were not a family. That's completely inappropriate and it's obnoxious, but it was a real prejudice that people had. It was a bias. And it's important to show the particularity of the relationship between these two individuals, that they are a family, that the particular security and safety that they gain with one another, the sense of stability, love, and trust, is everything to both of them. And, you know, these may be people who can't have children. These may be people who have suffered in previously abusive relationships, and so on. Another huge example of particularity of relationships is gay marriages, where, you know, these are individuals who may have a very healthy, loving relationship in the United States with friends or family, whatever, they go to work. But in the respondent's country of origin, the marriage will not only be recognized, but they won't have the opportunity to have the same quality of relationship or live a dignified life in that way. Perhaps they won't be able to walk down the street holding hands, and numerous other restrictions and privations. The fourth example in particularity of relationships are the elderly. You know, there's this assumption that, elderly are much more adept at caring for themselves than younger people. And, you know, the truth is, when my children were younger, they had much better ability to take care of themselves than my, 80-year-old mom. It's because we think children are so helpless that we have to hover over them for their every need. But there's a bias against elderly, and we don't sufficiently ask questions about to what degree the elderly qualifying family member is independent. In fact, it's not unusual when I get cases referred to me, the client will call and the client will say, you need to evaluate my children because of a cancellation removal case or whatever. They're the qualifying family members. And I'll say to the clients, well, do you have parents in the United States? And the client will say, yes. Why is that important? I say, are the parents, green card holders? Are they American citizens? And they'll say, yes. I'll say, well, it's quite possible that these are qualifying family members that are crucial to the case. And they'll say, well, my parents are elderly. I'll say, the fact that they're elderly, that they have a particular sense of, they may be fragile or vulnerable because they're geriatric and rely on you all the more, that it would make it very important to establish the particularity of a relationship between you and your elderly parent. Is it crucial for you, for example, to monitor their medication or assist them with doctor's appointments? I have many clients whose elderly parents don't speak English, and the clients have to act as an English-speaking conduit for the elderly parent in the community for their health care and other needs. The next major clinical forensic area of hardship is separation hardship. This is a huge area that is not delved into sufficiently. I'll give you one or two examples. Is it the case that there will be the inevitable and perhaps permanent separation of family members? This is especially true if you have children of varied age. In other words, let's say you have a child who's 19 years old and two others that are perhaps middle school age or younger. And the 19-year-old goes to college. Maybe he's in first, second year college pursuing a degree and plans to stay in the United States, not only to complete her college education, but for professional career reasons. maybe she has a significant other, and so on. So that if the client or the respondent has to return to his or her country of origin with the younger children, because children who are minors clearly have to be supervised with parents, it's going to mean not only the separation from the 19-year-old from her parents, but it'll be the separation of sibling and sibling. And very often that 19-year-old may have been a surrogate maternal caretaker for the younger children. So family separation is very important. For that reason, I see a lot of families that are intergenerational, immigrant families where 3 or even more generations are living under the same roof. I see a lot of cases with extended family members, and that should be noted also. For example, I'll see a family where, the guy has 2 qualifying children, but he also has a nephew and niece living with him for one reason or another. The nephew and niece are not qualifying family members, obviously, but his children have grown up with the nephew and niece as surrogate siblings, as step siblings, whatever you want to call it, and they make up a crucial part of the family constellation. Another major issue of separation is that half of all families in the United States today, or a little more than half, are blended, meaning children in more than half the families do not grow up with their mom, dad, and siblings. They grow up with a step sibling, a half sibling, a step parent, and so on. I'm not saying this is bad or good. I don't want to go into those kinds of issues, but just be aware that when you're looking at the family, to my mind, you're looking at the household. Who lives in the house? And the other question is, why do people live in this house? I had a case a few weeks ago where a grandmother was living in the house, and I initially thought the grandmother was there because my client was helping the grandmother. It was the other way around. The grandmother was helping my client because my client had a history of very severe problems. She had a injury at work that caused a severe lower back injury, prohibiting her from properly caring for the children, and it was her elderly mother who was helping her. That's very important for family separation issues, and it dovetails into physical hardship issues because you think, well, okay, her mom's helping her in the United States. What if she has to go back to Ecuador? How is she going to manage on her own with this severe back issue caring for these young children? The last area of clinical separation issues concerns country of origin issues, actually. In many cases that I see, clients will tell me, look, even if we go back as a complete family unit to my country of origin, you need to be aware that we may have to separate. Bilingual or proper school programs for the children may not be in my small town. I may go back to my small town and we get a home, but I have no work, so I have to travel to a major city, which may be 2, 3, 4 hours away, to provide monetary support for the children. All sorts of reasons that reflect why, quite possibly, even if they return to the country of origin as a single unit, they may not live under the same roof. The next major area of hardships in clinical forensics that we look at is medical. This is one of the most common questions I get asked, which is, what are the criteria? It's broken down into 6 main areas: diagnoses, symptoms, history, treatment, recommendations, and most importantly, prognosis. I'll just go through it very quickly. You should know some doctors' offices have switched to a format on the medical notes where all of these criteria are actually available to be seen discreetly in separate boxes. It's just amazing. Other doctors, as you probably know, when asked to write a letter on behalf of your client, will not include these criteria, and it's very, very unfortunate. So diagnoses. What do I mean by diagnosis? I mean everything. All major and minor medical and also physical issues should be included. physical therapy, occupational therapy, speech therapy, chiropractor, dental, anything and all that's healthcare related. That's what I mean by diagnoses. Clients consistently omit physical issues because it's not a medical issue. Physical issues are a medical issue. They just don't understand it as a medical issue because that's not how they conceptualize it. Everything should be included in diagnoses. I'll give you another huge example. Excuse the pun, obesity. It's a major issue in the United States. It's a very serious issue. And clients who are overweight or obese will not include this as a diagnosis because they've contended with their weight issue for many, many, many years, sometimes, since their childhoods. It should obviously be included. Another huge area that's not included is sleep. Insomnia is a very serious problem. Anything and everything. Okay. Next, symptoms. Don't tell me that the person is overweight. Tell me what the issues and symptoms are. Does it reflect an eating disorder? Do the symptoms reflect metabolic problems, or is the person pre-diabetes, or do they have diabetes, or type 1 or type 2, whatever it is? So be very specific. This dovetails into another issue, which is that I often give a brief explanation, and I'll give you the classic example. There are many different kinds of diabetes. The prominent types are type 1 and type 2. Diabetes 1 and type 2 share the word diabetes, obviously, in the name. They have nothing to do with each other. Diabetes type 1 is basically dysfunction of the pancreas because it doesn't produce insulin. And type 2 is a blood sugar disorder because the insulin is not properly utilized in the body. It's two different pathologies. The point I'm making is it's good to have a few lines explaining what the medical issue is because the reader of the report, judge, TA, adjudicator at the USAS, may not know. The next step within medical hardships is history. Include everything. Have the doctor include, for example, have there been emergency room visits or clinic visits? Is this an acute problem? Is this a chronic problem? Everything. Treatments. Treatments includes everything also. Prescriptions, general treatments, secondary aids, and so on. Recommendations. All best medical practices should be included, hopefully, by the doctor. And last is prognosis. What would occur if the child's parent is forced to leave the United States and the child is forced to reside in the country of origin without proper healthcare supports and so on? This includes specialty care and many other issues. I'll give you one great example. I often ask my clients, did you have pediatric care in your country of origin? And the clients will say, no, we didn't have pediatricians. Pediatricians are specialized physicians. They went to some kind of general doctor if they went to doctors at all. And the other question I asked, well, did you ever have specialists? If you had a breathing problem or your sister had a breathing problem, did she go to a pulmonary specialist or whatever? And almost inevitably, the answer is no. So these are the 6 steps of medical hardships that need to be included as a clinical criteria. The next major forensic clinical criteria is healthcare hardships, other than that, what we just spoke about. And I'll give you some examples. One huge one, again, excuse the pun, is obesity. I'm just going to repeat it again because it's so common given our healthcare issues in the United States. I very often find medical notes where a client is obese and it's not noted. It should be noted in my report and hopefully some explanation and context to it. And I'll give you one example. I'll see clients who are obese and they'll say, I have to tell you, one of the reasons my husband is so crucial to my life is because he helps me to monitor my diet. He helps to monitor caloric intake. He cooks for me. He ensures that I eat healthier meals, that I don't binge on sugars and fats and so on. That reflects something wonderful, not just a healthcare issue that is not properly documented by the physician, but it reflects a basic relationship issue between the qualifying family members or whoever is petitioning and the other individual. Another healthcare issue relates to ADLs, which a lot of lawyers are not familiar with. These are activities of daily living. That reflects the degree to which the client is able to contend with his or her environment. Can the person shop and cook and clean? Is the person able to go outside? These could be physical limitations of various kinds. Can the client attend to his or her personal hygiene or take a shower or bath on his or her own? Important issues. Another healthcare hardship issue relates to the country of origin. This is very important because many times we'll see clients who say, oh, I grew up in a terrible place. There's deadly insects and the water's unclean and the food's unclean. We didn't have air conditioning and terribly hot weather and so on and so forth. In many of these cases, I see clients who've sent one or more children to their country of origin to visit with extended family members. And the American children get sick with these exact issues. They suffer gastrointestinal problems, flu-like symptoms, and so on because of infected insects or polluted water, polluted food, and quite frankly, in many parts of the world now, polluted air. And it becomes extremely important. Many of these clients grew up in countries where there was the unavailability of medications, healthcare insurance did not exist, and many clients either had to rely on fake medicines, and many just relied on herbal supplements in their country of origin. Whereas, of course, in the United States, we have the availability of real medicines and other sorts of secondary healthcare supports. Finally, I see clients who will tell me, oh, no, there are good hospitals where I lived. And I'll say, oh, you went to those hospitals? And the client will say, no, I never went to the hospital. And I'll say to the client, well, if they're good hospitals in your country of origin, why didn't you go? And the client will say, well, they're good hospitals, but only in the major cities. And to be 2 or 3 hours from a major city is very difficult. Many clients come from places where they don't have cars. It's not just that cars are too expensive in these countries, but what Americans don't understand is that the price of fuel is prohibitively expensive. And many of these clients in their countries have alternative vehicles, such as mopeds. Well, if your daughter breaks her leg on a farm 2 hours from a major city, you can't necessarily take her on a moped. It's not sustainable because of the injury. So looking at healthcare hardship issues is very important with all these examples. Another area of forensic clinical evaluation, the hardship criteria, is education. This is a huge area. Obviously, you want to know if the client has a learning disability, math, reading, and so on. Has the client had an IEP, an individualized education plan? Be aware that if the client has an IEP, especially in New York, it'll have a diagnosis such as whatever it is. I mean, reading, math, learning. It's a single diagnosis. It doesn't mean that the child doesn't have multiple issues. It just means that in New York State, the IEP can only carry a single diagnosis on the heading. I know this from personal use. So all this needs to be included. Does the client have an intellectual disability? Does the client need special education programs? Is the client in a charter school? What is the cost of education here? Most likely zero. What will be the cost of specialized or bilingual education in the child's, if the child has to go to the parent's country of origin? It may be prohibitively expensive. Bilingual programs might not be available. Schools might not be available. You may have schools where there's one teacher for 3 or 4 different grades. Many clients tell me they didn't go to school because they couldn't travel. Sometimes they can't travel for physical reasons. Sometimes the clients can't travel to school because of safety reasons. Some clients abandon their education because they have to work to supplement their parents' meager incomes. All sorts of things. The other extreme is also true. You may have children who are honor roll students or are gifted and talented, or they show incredible acumen in one particular area, so they may go to a specialized school in high school where there are all sorts of programs to supplement their education. For example, I saw some kids who were very interested in math and engineering in high school, and their school had a robotics program. So many of these issues are very, very important. If the client seems to have a special education issue and there's no documentation and you have a little bit of time, have the parent go to the teacher or the principal or whatever and say, please get an evaluation for my client, for my child. The problem with this is that it's all free. And because it's free, the teachers and the school board are sometimes reluctant to do these evaluations. And as such, the immigrant parent really has to push. It's all the more difficult because the parent may not have strong English language skills and, as I noted earlier, may not understand the child's educational challenges at all. But if you have time, get these evaluations early. Another huge forensic clinical area that is not talked about enough is language. Many clients have children who are bilingual, but many clients don't. Just because you have two clients that come into your office, a mom and dad, and they have two kids, and the mom and dad are fluent in Spanish, don't assume your clients' children are fluent in Spanish. They may speak broken Spanish. They may not be able to read or write Spanish. Their comprehension and expression may be limited. I also see clients where they have specialized languages that are non-national or particular to a group or even a tribe. I see this often in West Africa. But this has also become an issue that's reared its head in South America, particularly in Northwest area, with languages that cross the border. And there's been a revival of some of these languages in South America. And it's an important issue to consider and ask about. Many of these clients will require bilingual school programs to keep up their English in their parents' country of origin. It may not be possible. This may be very impactful in other areas as well. For example, employment. You may have clients who only have a grade 6 education. They're deported or they have to go back to wherever it is. Can they get a job with their limited language skills? And if they can't, how are they going to monetarily support their children? Many clients also tell me that without proper language skills in their country of origin, they, but also their American children, will be socially isolated. They may be stigmatized. The other thing is that because of the language barrier and the accents and so on, some of these children may be targeted. It's going to be clear by their behavior, how they dress, their accents, their limited language skills, that they're foreigners, and they could be targets for robbery, even for kidnapping and other kinds of criminal stuff. The next major area in clinical forensics for the hardship issues is safety. Obviously, this is foremost in the minds of criminal immigration lawyers, of immigration defense lawyers, pardon me. It's not just the level of crime and violence. There may be terrorism and gangs and so on in the country of origin, but it's how these issues could affect the American citizens on a day-to-day level. For example, would they be even able to access the community? Could they travel to school? These are particularly important issues, especially if there's the ubiquity of violence, kidnapping, and so on. And also if there is the ubiquity of government or police corruption or ineptitude. There are also community hardship issues that I always include in evaluations when I write reports. You may have a child here who accesses the community, or an adult who accesses the community in a particular way. The family here may have extended family support that act as a peer social support system crucial for family members' growth and development. Children require a structured, stable environment to grow. They require certainty to feel safe. And without those community supports, it could undermine their growth or jeopardize their development in various ways. There can be concrete supports. There may be a general sense of support that a child has. One of the very first cases I did, this was almost 20 years ago, I had a dad who I evaluated with two children from Boston. The mom had committed suicide. To me, it seemed like a no-brainer, but it was a difficult case apparently. That's immigration court for you. And the children actually had adjusted quite well. Obviously, it's a horrible tragedy. They were going to school. Their grades were good. They had a very positive relationship with their father. And I was thinking, like, what to write. The children are doing well. They had no medical problems. The father had a good job. He was educated. He could theoretically, get a decent job in his country of origin. But what I realized was that it was the community that was therapeutic. In other words, the community itself provided a therapeutic environment that allowed them to maintain a healthy trajectory after their mother took her own life. They could attend the same church, attend the same school, attend the same hobbies and activities, sports and so on Saturday, Sunday. It was the community itself that provided a therapeutic holding environment that allowed these children to continue to grow in a loving and healthy way even after the loss of their mother in that terrible tragedy. There are also cultural hardship issues. The clients here may be very American, as one would expect, and they may be forced to return to a place where American values and culture and language and dress are completely foreign. Just because a child's parents are from a particular culture or country doesn't mean that's how they identify. I often see parents here who've been separated from their country for 15, 20, 25, 30 years, and they're physically and emotionally distant from their country of origin, and they wouldn't know how to survive there. And it's a very different culture, and certainly their children or spouse couldn't survive there, and they would be seen as very, very out of the ordinary. A major area, and I don't know why this isn't talked about enough, are just female hardships. In many of the countries that I deal with, there is pervasive misogyny. Women and girls have suffered physical, sexual, emotional, other kinds of abuse, domestic violence. Women are second-class citizens. They don't have the same education, employment, community opportunities. There are often few, if any, social supports. The police don't help. Fathers, brothers, and husbands are considered all-powerful within the home. Women may be limited also in their socialization, how they dress, what kind of basic activities that they can engage in, and their lives can be severely, severely limited. Obviously, financial hardships are very important. I often see families with two incomes, and losing half of an income can be devastating. I also see families with one income for various reasons. I just saw a family the other day where the dad works full-time. He's a landscaper in Long Island, and the mom stays home and has not worked for many years because she has an autistic child who has special needs. Well, if he's deported to Guatemala, how is this mom going to work full-time to support herself, to support her autistic daughter, and also send money to her husband in Guatemala because he's not going to be able to work there? There could be all sorts of issues, car payments. They may have monthly mortgage bank payments that would no longer be able to be maintained without the second income. The house would go into foreclosure. It'd be a huge financial loss. Many times I see clients with children who are older. They're in their late teens or early adulthood, and there's college tuition payment. Many clients talk about a huge onus of having to pay for their children to fly back and forth from their country of origin, which is financially prohibitive sometimes, but it can be logistically prohibitive, physically prohibitive. Many children don't want to fly on their own. And many clients would be going back to a country where there may simply be no jobs, very high unemployment, wages may be extremely low, there may be a terrible economy. There's this perception, I know that Americans have, that one of the things about living in a poor country is that it's relatively cheap to live in a poor country. That's not always true, and poor countries can have actually, for various reasons, high cost of living, and they could also have inflation. So for various reasons, financial hardships are obviously crucial to consider. I also look at special abilities. For example, we talked about education. Does the client's children or the client have special education needs? But is this client outstanding in some ways, attending a gifted or talented program? I saw a case where a child was doing very poorly during COVID and joined the wrestling team. And the coach from the wrestling team helped boost this child's self-esteem. The child did very well, socialized. The amazing thing was the following 2 semesters, the child's academic grades also rose. So here's a child who is given an opportunity to be on a athletic team, on the wrestling team. It's a special opportunity that won't be available in the country of origin, but that opportunity has also raised the child's self-esteem, socialization, and academic abilities and accomplishments. There are all sorts of special abilities and opportunities. As I said, there may be special supports from other educational programs, family, and therapeutic supports. You may have a child who's been in therapy for many years and wants to continue with the same therapist. You may have an adult or child who's been with the same specialized doctor for many years and wants to remain with the doctor because they feel very confident that this doctor really provides for their needs in a proper way. There are all sorts of religious and cultural hardships that could be expanded upon, which are another criteria in forensic evaluations. I'll see clients who are part of a religion that's very, very small. That's, may have some voice in the United States, but has a much smaller voice in the client's country of origin, and especially if the clients have come from a small town or agrarian village where that religion will be not represented at all. I see a lot of clients also that gain a lot from their churches here. And I just saw this the other day with that client who had an autistic daughter. The clients are part of a Pentecostal church here, and they worship there, and that's great. But they have developed a very positive relationship with their pastor, a very positive relationship with fellow parishioners. They're very challenged with their autistic daughter, and yet the other members of their church are very supportive and loving. That's an important community support. It's important religious support. It provides spiritual sustenance and so on, and that should be considered. Another huge issue, which is never really talked about, is adolescent developmental sexual issues. This has become hugely important in the last 10 years because of sexual identity. And I'll give you one example, but there are many. I saw a girl about 3-4 months ago, and I think she was about 15 years old, and she spoke about depression she was suffering because of her sexual identity. And it was not because of her sexual identity as such, but rather her parents are very conservative. They came from a country where this was not talked about, from a small community. And she was having difficulty with her parents accepting her. Now, this is a 15-year-old. She's talking about this crush that she has on another girl in her class, and how sometimes she will hold hands with this girl, and she's accepted by her friends, and they talk openly. And she's very comfortable in her community and very comfortable in this relationship. That's wonderful. What's this 15-year-old girl going to do with this developing sexual identity in her parents' country of origin in a small town where she cannot hold hands with another girl, where she will not have counseling available, where perhaps the church will degrade or demean her thoughts and feelings? This is a very serious developmental issue. It's not usually asked about for children or even young adults. I ask about it. I think it's important. There are ways to do it that are kind of gentle and appropriate for age and for context. But I think it's a huge clinical forensic issue. The last major issue I want to talk about in terms of criteria are obviously psychiatric issues. Is there a history of depression, anxiety, PTSD, learning disorders, and so on? Please be aware that the clients you see are coming from countries where there's the ubiquity of violence and poverty and alcohol and drugs and police and government corruption, social and political unrest. all sorts of problems, and misogyny, and it's quite common for clients to have suffered PTSD in their country of origin. And what will it be the result if these clients have to go back there? What will be their ability to function? Will it impact the quality of paternal or maternal care that they can provide for their loved ones? In some of these cases, the clients will present without any documentation. Some of these cases, a lot of these cases. And just because they don't have documentation doesn't mean these issues need to be asked about. And I often get clients telling me, I know I don't have a problem because it's not documented. Documentation has nothing to do with the problem. It just means it hasn't been documented yet. So psychiatric issues are important. Please be aware that in many of these cases, the fact that something's not documented, you have to ask and elicit information about it in an all more sensitive way. It relates to hardships very directly, and it often spiders in ways that relate to all sorts of different criteria that we've spoken about so far. So those are a large set with subsets and examples of clinical forensic hardship criteria that are relevant in cases. I just want to talk a little bit about the hardship clinical interview challenges for a moment or two. In many of these cases, multiple meetings are required, at least one or two, but clients do not want to come for multiple meetings, and this is a problem. Research from the USCIS shows that it's not absolutely necessary. I have some tricks of the trade. One is I have the clients come in and I'll say, we really can't start the case until you sign off on a form of agreement and I get a deposit or so on. I really do this so I get the clients to come in more than once so that I can do an initial evaluation, a screening, and so on. And I often like clients to come in to pick up reports rather than to send them to lawyers, so I can have the clients come in yet again. We can have a follow-up session, even if it's only for half an hour. I'll say things like, is there anything you think you missed, areas that we didn't really cover properly, and so on. There is a point of diminishing returns. This is not psychotherapy. It's a forensic evaluation, but multiple meetings should be considered. Include all family members. This is very important for hardship criteria. I know in many of these cases, family members do not all live under the same roof or even the same city or the same country, but sometimes that needs to be considered. I had a case many years ago. I travel outside of New York all the time and sometimes even outside of the United States. I had a case where an American was petitioning for his wife, and they were living in Aruba. They were living in Brazil, and it was a very difficult case because, of course, if he was living with her in Brazil for so many years, what's the hardship? I mean, they have a home, he's working, and so on. And I explained to them that this was a very serious case, and I'd need to evaluate them. This was at a time when Zoom was not as popular, but I always tell the clients the benefits, but also the drawbacks of an audiovisual evaluation. And it ended up meeting the clients and the client's parents in Aruba because it was halfway, and also the client lived in an area of Brazil where there was very, very high crime rate. It was a very expensive case. I felt very self-conscious about charging the clients, but the face-to-face interview with the client's wife yielded great information about the waiver. She committed fraud previously, and what I learned from the face-to-face interview was why she committed the fraud. It had to do with abuse that she suffered in her family of origin. She was trying to escape. She felt a terrible sense of shame, and ultimately the case was granted, thank God. But it's really an example where you have to include all family members. You get the source of the information directly, and the availability of face-to-face evaluations can be just priceless. Don't forget there are two sets of hardships. Hardships that the family member will suffer if the other family member is forced to return to his country of origin, but also the hardships that the petitioner would suffer if she has to return to the country with her husband. If it's a spousal case, it could be children involved in cancellation removal case, and so on. So there's at least two hardships. But I always think about hardships also for the non-qualifying family members that can serve as an extension. And, as I said, you may have a case where, a woman came, and I mentioned this before in part, but came from a place where she had suffered physical sexual abuse in a previous relationship, and she's then forced to go back to that country, and it would trigger for her a profound sense of sadness, anxiety, and uncertainty, and guilt even. How can she provide proper maternal care to her children if she's forced to live there? It's important in these hardship cases to be very explicit about the nature of the evaluation, what is being evaluated, who's being evaluated, and so on. It's important also, and I say this very often, to have an expert evaluator. Psychotherapists don't have expertise in this. If it's an immigration court case, they don't want to testify. They're worried about liability. They don't have proper notes. They don't know what in the world they're going to do to explain to a TA who's harassing them and being very, when there's frankly aggressive confrontation about a hardship criteria. It's not pleasant going to court, I will tell you, to testify. I've had some generally positive experiences, but I've also had negative experiences. That's fine. That's part of my job. But a psychotherapist who's not used to it may just not have the wherewithal to do so. And the other thing is, the psychotherapist is basically providing a psychotherapeutic mental health evaluation and presenting it through what the person gains through the sessions with the client. That's not what I'm doing. I'm doing a forensic hardship evaluation that also looks at criminal mitigation issues. If there's, we talked about that in other programs, if there's crimes or misrepresentation or fraud upon entering the United States. I'm looking broadly at hardship criteria. It's quite possible that you may be dealing with adults and children who have no mental health issues at all. They're healthy. And that the hardship criteria that you're looking at in this specific case is completely different. They may have to do with educational issues, family, environmental issues, or whatever. Many clients who do have mental health issues, please be aware, and it can serve as a hardship criteria, don't seek assistance because psychiatric care is anathema to their cultural background. Mental health diagnoses are stigmatized. They may have shame about it. They may be ignorant. They may not have financial resources. Many of these clients gain support from their pastor or fellow parishioners at church. So just because a client does not present with a documented history of mental health issues and they failed to have sought out mental health support or assistance, even through support groups or whatever, doesn't mean that these issues don't exist. The overall goal for the hardship evaluation is to humanize the client through a sympathetic psychosocial narrative and evaluation and document the client's life history. As you document the client's life history and through the evaluation, you should be hitting on the major criteria of hardship itself. In other words, it's almost like res ipsa loquitur. The thing speaks for itself. The evaluation itself should tick off the major areas of hardship for the case. In many of these cases, professional expression must replace self-expression for hardship criteria. The client does not have the wherewithal. They don't have the education, the English language skills, and so on. Just like the client needs a immigration defense lawyer, the client needs a forensic expert to explain their issues. The single document theory, which I've spoken about in many programs over the years, it means that it's not just about mental health issues. It's a aggregate of all sorts of issues, and the immigration lawyer may hand in, a packet like this of material to prove hardships. And it's important to take little bits and pieces of those issues, include them in the report, so that in a short 20, 25 page, 30, 40 page report, whatever it is, all these issues are included in a coherent and cohesive way. Cumulative factors should be stated, interweaved, and so on. Research should be included sometimes. Explanations should be included sometimes. I look at United States travel reports, CIA. My favorite is Borgen, Borgen. Borgen reports on country conditions, I think, are really well written. They're very short and digestible. If it's a case that goes to immigration court versus adjudication through USCIS, there's a very different kind of opportunity to present the hardship criteria, speaking directly to the immigration judge face-to-face or answering questions for the TA. What I would say is beware of stipulations. Nothing replaces live testimony, and to simply have the expert's report stipulated to and accepted into the record sounds good. I mean, we all learn about this in law school. It's great for appeal purposes, but you want the judge to really internalize it. And I see a lot of cases when I used to go to court where I know the TA has looked at my report for the first time when he or she gets to court, and they first look at the conclusion, then some bolded areas. These are very long reports, and they need to be read once or twice or three times. And it's a huge advantage, therefore, of having the expert go to immigration court to really explain this stuff. I won't look at mitigation now in waiver cases where there's very often, as I said, fraud or misrepresentation or other illegal behavior such as CIMT or crime. I have a completely separate YouTube program for it. I've done separate CLEs on it. But I would say this, sometimes they are related to some respect. The classic case, of course, is someone who enters the United States through fraud or misrepresentation or even iwi, but they've done so to escape harm or persecution as a female in their country of origin, and they have a daughter, so that the harm that they've escaped, not only are they going to go back possibly to that same harm in their country of origin, but their daughter as a female may also be at risk for suffering as a female due to misogyny or whatever issues may be in that community. The last thing I'll just mention briefly, and I have this in other programs, is what to do if you get a denial in a hardship case. The joke is there are two kinds of lawyers: those who get denials and lawyers who get denials but won't admit that they get denials. Everybody gets denials. I've done cases where they're denials or RFEs. What I do myself is when I get the case, I look at it de novo. I look, what has the other expert missed? What questions should have been asked? What are the holes? What did the client do wrong? I have many cases where I tell the client, bring in this relative and this relative to help me understand your case. Bring in this document and this document, and the clients don't, for whatever reasons. And maybe now the client will wake up to the seriousness of the matter, and it'll be pressed upon them the urgency of bringing in these documents or relatives for the evaluation. It's not free. It takes time. Is it a second bite at the apple, an appeal or an RFE? Sometimes yes, sometimes no. One thing I will say, and this is something I've learned over the years, try to read between the lines. Very often, the denial is not necessarily based on the quality of the hardship issues that have been elucidated, but on something else, namely that the USCIS, for example, denies the case because of the fraud or misrepresentation or illegal behavior. And that's why criminal mitigation for immigration defense lawyers is absolutely crucial for every waiver case. The last thing I would say is sometimes in court, I'll see judges who substitute their opinion for the parent's opinion or for the expert's opinion. In other words, the judge will or the TA sometimes even, will see things in a way that is particularly idiosyncratic. And it's important to provide a corrective narrative for the TA or judge about the hardship issues as it is reflected in the forensic report. Thank you for listening today. This has been a CLE YouTube program, something I've done many, many times before. I'm presenting it for free for all lawyers in the United States, so they'll have an understanding of clinical forensic hardship concerns in particular for waiver and cancellation of removal cases. If you're interested in having me present at a local AILA chapter, I'd absolutely love to. If you'd like a redacted sample, please don't hesitate to email me. I'd be happy to send you one. My information will be in the YouTube page, and I hope this was helpful to you in your practice. Thank you.